Good morning. Today we're going to be talking about marriage-based adjustment of status interviews. This is one of the main types of interviews that we do at Whitlock & Gray. We consider ourselves pretty well prepared every time we go in with our clients for this interview. So after you've prepared the entire packet of all the forms and documents and you send it off, you play this waiting game and you're waiting for the interview. Oftentimes our clients ask us what they can do to prepare for their marriage-based adjustment of status interview. One of the main ways during this long waiting period that clients can further prepare for their interview is to continue to gather what's called bona fide evidence, or evidence that your marriage is in good faith and not for the purposes of immigration. So examples of this type of documentation includes financial documents such as joint income tax returns, joint bank statements, credit card statements with the other person listed as an authorized user, 401k beneficiaries, and so on and so forth. This also includes photographs and other mementos from the relationship, social media pages, things of that nature, flight itineraries if you take trips together, information on your honeymoon if you went on a honeymoon, such as a hotel reservation in both names, etc., etc. We encourage our clients to continue accumulating this type of evidence because one of the main things that we do when we go for a marriage-based adjustment of status interview is we prepare this huge packet of bona fide evidence. I prefer to do a detailed table of contents so that the first thing we do when we walk into the interview is to give the interviewer this huge packet of information that shows that your marriage was entered into in good faith. This tends to impress adjudicators. It puts them more at ease, and it makes them more likely from the get-go to want to approve your case. Then, once we get the notice of interview, we make an appointment for clients to come in and sit down with us to further prepare. We give clients a list of possible questions that will be asked. Of course, every interview is different, and oftentimes because we've given such a detailed packet of information, the bona fide part of the interview doesn't last as long because the officers already believe that the marriage was entered into in good faith. But we prepare for it anyway because you never know how an adjudicator is going to be feeling that day and what questions they might ask. So the interview is broken down mainly into two parts, and generally the first part is the bona fide issue that we've already talked about. Was the marriage entered into in good faith? Again, questions, documents surrounding that issue. There will be questions related to, have you met each other's parents? I always tell clients they need to remember their date of marriage, the other person's birthday, and the other person's parents' names. These are important things to know, along with other, of course, information about each other's families, etc. The second part of a marriage-based adjustment of status interview involves the beneficiary, so the immigrant that is applying for a green card, and whether or not that person is what's called admissible to the United States. So in order to obtain a green card, a person must be admissible. Now, there are some main ways that someone can be inadmissible to the United States. The first is, of course, criminal grounds. Crimes involving moral turpitude, which is a whole nother discussion in and of itself, can be a grounds of inadmissibility, and there are certain other types of crimes as well. It's very important if you have a criminal history to speak with an immigration attorney about whether or not those crimes make you inadmissible. The other type is immigration violations. So if someone has accrued some unlawful presence in the United States, so if they've been in the United States without permission, or if they've overstayed a visa, that can make them inadmissible to the United States, again, depending on their circumstances and what type of visa they're applying for. If someone is a U.S. citizen and entered lawfully, oftentimes unlawful presence is waived after that last entry on the visa, but if they had previously entered, that can cause issues. There are also sometimes issues with unlawful presence where it can make someone permanently ineligible for a visa unless they spend 10 years outside of the United States and then apply for a waiver of the grounds of inadmissibility. The last thing I want to highlight in terms of inadmissibility is the issue of non-immigrant intent. We get a lot of clients who apply for visas because after they come in on a tourist visa, so they enter on a visitor visa, and then they either get married or they are married and they want to adjust their status. There are certain rules surrounding that, and it's not necessarily bad to enter on a tourist visa and then adjust your status, But it's important to note that you cannot enter on a tourist visa with what's called immigrant intent. So you cannot plan to come to the United States on a non-immigrant visa with the intent to apply for a green card, because those visas are specifically given for the purpose of being a temporary visitor. Now, immigrant intent alone should not be a grounds of inadmissibility, especially when family-based adjustment of status is at issue. However, a misrepresentation made either at the time that you apply for a visa or when you speak to a CBP, a customs officer, on your way into the United States, this can become an issue. And so one of the main things that I discuss with my clients in the initial consultation is, were any statements made when you entered the United States? What did you ask? What did they ask, and how did you answer? What sort of plans did you in fact have? All of these questions are really important, especially given the current administration's environment that they've created, and how much of a crackdown on immigration there has been. So once those two parts, both the bona fide issues and the admissibility issues, are discussed in an interview, those are generally the main two things. And then the officer will make a decision on the case. Sometimes they make a decision right at that time. Sometimes they make a decision shortly thereafter. And in some cases, they request additional information that we have to provide. The last couple of interviews I've had, we've finished and my clients have walked out and said, wow, I felt over-prepared. And that's what I want my clients to feel every time. This should be something that we walk in there and we wow them, and it's easy peasy for us, and the officers from the get-go want to approve our case. So that's it on marriage-based adjustment of status interviews. Everyone have a great day. Bye.